So my name is Matthew Storey. I'm a special education and civil rights attorney here in California, based out of San Diego. I've been practicing specifically and exclusively in this area for a little over a decade. I've done a lot of cases, almost 1,700 cases here, including a lot of due process trials, federal appeals, and I've argued before the Ninth Circuit as well. I came into this field because, like most people, I have a brother with a disability, a cerebral palsy, and my mom alleges that she was one of the first advocates in California. We just let her have that. We're not sure. We can't confirm that. There was no internet in the 80s. I mean, that's pretty much it. My entire focus in career is on children, specifically disabled children, and their access essentially to the world, and more specifically education.
Awesome. Well, we're excited to have you here. Thank you for your work. We really appreciate it. So I have gathered some questions. A lot of the questions either I get asked personally or parents that I'm having consultations with through La Jolla Learning ask some of these questions. So I thought it would be great for us to discuss them, and you can definitely answer them to the amount of knowledge that you have in regards to law. So the first question is timeline related. So once a parent initiates kind of that communication that there's concern with their child, they have concerns, can you go over some major timelines that they can expect, how many days parents can expect to hear back from the school?
Sure. So there's several timelines that are important under the IDEA, and specifically in California. There's not too many, so it's easy to remember. But anytime a parent asks for an assessment in the state of California, the district has to respond to the parent within 15 days. And that is 15 days, that doesn't include days like, over summer or something along those lines, like Christmas break. The second timeline is once a district or once a parent has signed an assessment plan, meaning the district has agreed to conduct an assessment, the district has 60 days to conduct the assessment and then hold an IEP meeting to review it. And then another important timeline is IEP timelines, which is that when a parent requests an IEP, a district's required to hold that IEP meeting within 30 days of that request. I think it's important with those three, the 15, 60, and 30 days, to understand that, being a day or two late is not going to be a big deal. A lot of times parents will call me and say, I've asked for an IEP and it didn't start till day 36. Well, there's not much you can really do about that. And courts don't, to be frank, rigorously enforce those. But those are the ones you have to think about. The one that I get a lot too is when a parent requests an independent assessment, meaning a private assessment, which is paid for by the district, but that the parent gets to choose the provider. They're required to respond without undue delay. We have no idea what that means. It's an interesting provision in the law, but most courts find that IEEs are late if the district doesn't respond within about 40 days. And so those are kind of the main timelines within special education we want to be mindful of.
Got it. So kind of a side question to that, Matt, why would a parent request an IEE?
Mm-hmm. Yeah, so an IE, it's a really great provision in the law. It's a little procedural protection. And what it means is when the district conducts an assessment or even fails to conduct an assessment, a parent has the right to request an independent educational evaluation in that area. So for example, if the district does a speech assessment, right, a parent looking at that assessment may not like it and ask for an independent assessment. And the reason parents can request these assessments, there's a variety of them. Number one is that you look at the district's assessment and you just don't agree with it. Maybe that what the district is portraying within an assessment, you as a parent don't agree with it. Another reason may be just because you feel like the IEP is not working. That's a big reason to ask for one. Maybe you as a parent are looking year after year and you're not seeing progress, so you really feel like maybe the district doesn't have a handle on what's going on, so you request an independent assessment. Now, it's not guaranteed that you're going to get it. The district, when they receive a request, has only a few options. The first is they can grant it. And to be frank, most do. Most districts want to work with parents. And my experience, has, for the most part, been they'll grant them. The second part is they can deny it. And if they deny it, they're required to file what's called a due process, or essentially begin litigation to prove that what they did was correct. And so parents should always be cautious when you make that request that some districts may in turn file a due process, in which case you would want to call an attorney as soon as possible.
Got it. Thank you.
Mhm.
So another great question that I get is, how do parents know when would be an ideal time to reach out for an educational attorney? And how do they know what to look for in that search?
Sure. Well, I think understanding an attorney's role is important. A lawyer comes in and tries to correct something that a district is otherwise not doing. Right. So our job is to break down a barrier. So if, for example, a parent thinks, and just using speech again, that their child needs to have speech and language services or a certain amount and the district's not doing it, that is the province of an attorney. If the parent feels the placement is wrong and the district's refusing to do a placement, that may be where an attorney is. And attorneys work differently in our field. I never go to IEP meetings because nobody talks. Some people like to have attorneys at IEP meetings. Again, not a big fan, but that they do that. But I think there's a difference between an attorney and an advocate. And an advocate is somebody who walks the parent through the process, makes suggestions, helps develop an IEP. I'm a big proponent of that. I think, even myself, I have my youngest on an IEP. Advocate. I don't go by myself. But I think when that process becomes clear that the district is not going to do something that you might want them to do, that's when you really want to reach out to an attorney. Choosing an attorney in San Diego or California specifically, I think is pretty darn easy. Every attorney I know here in San Diego is very, very good. So what I usually tell parents, even if they're calling me, is call 3 attorneys, at least. Call 3, and interview them and see which one you feel like you're going to work with better. Because a lot of what we do is very personal. We're working with your kids. And so you need to be very comfortable with what you're hearing, how we communicate, and more importantly, how we work, because everybody works a little bit differently. But again, if you're in San Diego, you really can't go wrong. There's really, only a couple law firms that do this pretty seriously. And so anyone that I know of, you'd be in very, very good hands.
It's great to hear. So Matt, another question that I get a lot from parents is that they have the evaluation, their child is eligible for special education, they have an IEP in place, or they're in that process of it being created. How do they know that the IEP is an effectively written IEP?
That's a good question. An initial IEP, sometimes that's hard to tell until it's been implemented. So if you're a parent that's getting their first IEP, that's a tough IEP to challenge because it's never, nobody's ever done anything. So oftentimes in the case where it's your initial IEP, you've got to let it go, you've got to let it go for 6 months and see what happens and ask for progress reports. If in the alternative, you're a parent who's had an IEP for a while, okay, and you are concerned that you're not seeing progress, my advice is to start off by looking at what's been going on. Read the last couple IEPs. Specifically, one of the things I do in my practice, and I've always done, is I will grab the last 2 or 3 annual IEPs. I will open them up to the present levels of performance and just look at all 3. That'll tell you very quickly if your child is making progress. So if you have a reading issue and that has been the predominant fact within the IEPs, it's pretty easy to put 3 pages together and go, okay, what level were they reading at 2 years ago? What level were they reading at 1 year ago? What level were they reading at now? And compare it. That's one of the best ways to do it. If you're a parent that just, it's too tough to figure out, maybe you're not sure, then I would go back to the independent educational evaluation. That's a really good way to figure out, whether or not the IEP is working, whether or not the student is making adequate progress. That's a lot of times what we're doing with independent assessments, is we're either confirming or figuring out whether or not the IEPs are working. It's a great tool.
Awesome. Thank you for that input. And the last one kind of really hits home in regards to what we do at La Jolla Learning in providing those specialized services. That educational therapy is what's some advice that you can give to parents when they have the IEP, maybe they're not seeing progress, or they know that through their own research that their child needs this specialized type of instruction or approach, and the school just is not providing that.
Yeah. So that's a big issue, again, with reading, especially right now in the state of California, where we are coming up extremely short as a result of a variety of things. Mostly when you have kids with dyslexia, or issues with, different types of processing. And a lot of times schools do not have the appropriate methodology to teach the certain to the certain types of disabilities that we see. And again, if you are a parent in that situation, I am pushing you towards independent assessments very quickly as an attorney. The reason I'm doing that is because I can't tell you what type of reading program a student needs or what their particular deficits or disabilities might be. There are a variety of different, I'm dyslexic. There's a variety of dyslexias, that you need to know about. And you need an assessor to come in, pinpoint the issue that's going on, and then make a recommendation for the type of service or methodology that is required. Only then are you going to be able to push a district in the right direction.
Got it. And say that they have the IEE and it lays out that these are the types of services, the type of instruction that this student needs, and the school doesn't have someone who's qualified to teach that instruction. What should the parents then do? I know some of our parents come to us and they, they pay for our services through their own means, and then some of the parents come to us where the district is paying for those services. Can you tell us how that happens?
Yeah, that's a pretty typical due process case for a special education attorney. And how that plays out is that, you have a student, and again, we're just going to use reading. You have a student who has just been struggling with reading, and the district doesn't have the appropriate program or methodology to teach them. And we, as an attorney, we will often look at filing a due process against the school district to either provide that program, or if they're unable to do it, supplement it through what we might call compensatory education. And as you know, this is a service we would use through you guys, and the parents would then have the funds through the school district to pay for those services and remediate what has been lost.
Awesome. Matt, I really appreciate all of your knowledge. I appreciate all of your time. I don't know if you would like to, put a little plug in there, the name of your office. I don't think you said that at the beginning, and maybe if parents are looking for an educational attorney, how they can best contact you.
Sure. So mine's pretty straightforward. It's the law office of Matt Storey here in San Diego. The easiest way to get a hold of us is you can Google my name and I pop up first, or you can just give us a call, and it's 858-433-1060. And like I said, one of the best things for attorneys is call several. Don't just call one. Figure out who you would like to work with. And you really, again, in San Diego, you're not going to go wrong.
Awesome. Thank you so much.
My pleasure.